Welcome everyone. Thank you for joining us for today's webinar. My name is Danladi Irimi Akifasi and I am the Chairman Planning Committee for this second Ephraim Arbitration Day. Ephraim Arbitration Day is a day set aside by Honorable Shola Ephraim Oluwanuga Imenai to contribute his quota to addressing some current issues affecting arbitration practice in Nigeria. The theme of today's discussion is due process paranoia in Nigeria arbitration practice. The concept of due process paranoia, according to academic writers, is a perceived reluctance by arbitral tribunals to act decisively or courageously in certain situations for fear of the arbitral award being challenged on the basis of a party not having had the chance to present its case fully. The objectives of this meeting, therefore, are 1. To examine briefly the concept of due process in arbitration. 2. To appraise the place of the New York Convention and other institutional arbitration rules in the prevention of due process paranoia. 3. To assess the effect of due process paranoia in Nigeria arbitration practice. 4. To review international trends in the judicial attitude to the prevention of due process paranoia in civil and common law jurisdictions and consider lessons learned. And finally, to profile recommendations and implementation strategies to address due process paranoia in Nigeria arbitration practice. This webinar is hosted by the firm of O.S. Ephraim Oluwanuga and Company and supported by Ephraim Consulting. Now, without further ado, I will turn the time over to the chief host and moderator of this event, Mr. Ephraim, to continue with the proceedings.
This is the second Ephraim Arbitration Day. The theme of this course is due process paranoia in Nigeria arbitration practice. Due process paranoia is defined as perceived reluctance by the arbitral tribunal to act decisively in certain situations for fear of the award being challenged on the basis of a party not having had the chance to present his case fully. This is according to Queen Mary University and White and Cates survey. For an appreciation of this concept, there are basically 3 well-recognized components to consider. We may describe these as 3 symptoms to be seen when an arbitral process is fraught with due process paranoia. The first thing you will notice is that case management is that of case management. The second component is the demonstrable belief on the part of the tribunal that such a cautious stance is necessitated by the risk that the tribunal's award may otherwise be set aside or refused enforcement, that is, enforcement risk. And finally, the third component to be recognized is that the fear of enforcement risk is perceived by the tribunal as being warranted. This is referred to as risk averseness caused by an inflated perception of enforcement risk. Now, there are several different scenarios of the overly cautious case management, but I will give you just 2 as I'm sure our speakers will elaborate on this. 1. Granting repeated extension of time at the request of one party. Accepting written submission filed in breach of the procedural calendar, among others. The question is due process paranoia in arbitration practice in Nigeria a reality or an illusion? That is the question. If it is a reality, how do we address it? If it is an illusion, how should we recognize it? To engage these thoughts, I have 4 witnesses, 4 key witnesses. They will look at the theme from 4 different perspectives. I shall cross-examine them if need be, and the participants will have the opportunity of re-examining them at the end of their collective presentations. My first witness is Ben Garretta, who will be laying the foundation of the topic. Who is Ben? Ben is an international dispute resolution lawyer, a chartered arbitrator, and a mediator. Is a partner in the dispute resolution department of Miscon Durea LLP and is the chair of the London branch of the Chartered Institute of Arbitrators. His experience spans a number of industry sectors, including oil and gas, mining, petrochemicals, shipping, construction, engineering, and infrastructure. He has represented clients on disputes throughout the world, including Europe, Africa, and Asia. He is currently based in London, and between 2009 and 2016, he was based in Singapore. Ben Garretta, please approach to give us your perspective. Thank you.
And finally, I'll talk about some of the ways that people have found to address due process paranoia. And in all of this, I'm going to be speaking from a very international angle rather than referring to specific case law in Nigeria or other countries. So firstly, the reasons for due process paranoia. Now, these will be very familiar to all of you, I'm sure, but let me just mention them nonetheless. I think there are 3 main reasons for due process paranoia. And the first 2 can be summed up in Article 18, Article 19 of the Untitled Model Law, which I'm sure you're all familiar with. Article 18, as you know, says the parties shall be treated with equality, and each party should be given a full opportunity, each party shall be given a full opportunity of presenting his case. So there you have a key principle in arbitration of equality and due process. But just next, in Article 19, it says that subject to any agreement of the parties, the tribunal may conduct the arbitration in such manner as it considers appropriate. Now, that principle, of course, reflects the principle of flexibility, which you'll also be very familiar with. But it's very drawn up in very broad terms. So straight off, we have a possible a question arising. Parties have to be treated with equality, but how? In the context of a system where the tribunal has a great deal of discretion about how they can proceed with the arbitration. So those are the first two points leading to due process paranoia, the emphasis on due process and the flexibility in arbitration. And then we have the third factor, which is the lack of appeal in arbitration. Now, the lack of appeal, I mean a lack of appeal on substantive grounds, means that very often parties will seek any means by which to complain about a decision that may have gone against them. And as you know, instead of a lack of appeal, there is a possibility of challenging an arbitrator's award and an arbitrator for failure to comply with due process. And that challenge route, I believe, is exploited in many different ways, and perhaps more often than it would have been if there was a right of appeal in arbitration. And that is very nicely illustrated by the fact that, certainly in the English courts, there are a relatively high number of challenges to arbitrators' awards on the grounds of due process, but actually very few of them succeed. There is what the English courts refer to as a high hurdle for such a challenge to succeed. And indeed, it is a very high hurdle, which does suggest that many challenges that are brought simply by way of complaining about the award, and in the absence of any other route to complain about the award, any route to appeal the decision that has been reached. So there we have the three factors that I believe contribute most to this due process paranoia. Now, what are the consequences of those factors? Well, I believe that we're now in a world where there is a considerable amount of anxiety. Of course, there's a lot of anxiety during the current months for other reasons, but within the arbitration world, I believe that because we have seen an increasing number of challenges on the grounds of due process, and challenges both to the appointment of arbitrators and to the arbitration awards, this has led to a considerable amount of anxiety on the part of arbitrators. Now, where does that anxiety lead to? Well, it leads to arbitrators being overly cautious about their approach to arbitration. And the result is we have overly long processes, we have overly long awards, and a general tendency of arbitrators not to be flexible, not to be firm in their approach to an arbitration for fear of facing a challenge. Whether that challenge is meritorious or not, they are afraid of facing a challenge. So they do err on the side of allowing the parties too much leeway rather than being firm about the process that should be used in the arbitration. Now, what are the ways? I should say the other consequence of this course is we have seen a proliferation of soft laws in arbitration. As you well know, these are guidances issued by various institutions and bodies by way of guidance and filling the gaps in arbitration and helping arbitrators to overcome this due process paranoia. And that takes me on to the last topic I want to mention, which is the ways that can be found around to deal with this due process paranoia. Well, I think there's a few things. One of them is actually the soft law that I have just mentioned, and you can see increasingly guidance is being issued to arbitrators to help them, to give them more confidence in addressing the possibility of due process paranoia and the possibility of being challenged for whatever they've done during the arbitration. And a very good example of that came out a couple of years ago, which is the Prague rules on effective processes in arbitration, which again, many of you will be familiar with. Now, the Prague rules doesn't say anything particularly new or striking, but it does give an arbitrator a clear mandate to behave in a proactive manner, to behave in a firm manner, and to avoid a feeling of due process paranoia. Other ways in which this due process paranoia might be addressed, and in fact is addressed, I believe that training could be offered to arbitrators to deal with the due process challenges in arbitration. And as part of that training, arbitrators might be more aware of the project management of arbitration. I've seen many arbitrators who are very content to sit back and simply let the arbitration unfold in front of them. Whereas if they were more active and more proactive about managing the arbitration, perhaps some of these fears about due process challenges might fall away. And the other way in which it can be dealt with is through the parties' own agreement. If we go back to Article 19 of the model law, you'll recall that the tribunal has a broad discretion subject to the agreement of the parties. And we are seeing more and more the parties agreeing to processes which give the arbitrators greater powers to act and to avoid possibilities of due process challenges. Those agreements are very often not direct. They're very often not found in arbitration agreements, but they're found through parties' agreements to incorporate certain rules, such as the SIAC rules and the ICC rules, which contain expedited processes, and thereby empowering the arbitrator to act more firmly in appropriate cases. And these expedited processes normally apply in cases which have relatively low value to them, although sometimes the parties can agree to it even if the case is of very high value as well. And I'm sure Tunde can speak in quite some detail about the ICC processes. So that's my introduction to this topic, the 3 points, the reasons for this due process paranoia, the consequences of the due process paranoia, the anxiety that has arisen, and finally some of the ways in which parties and the arbitration world is trying to tackle the due process paranoia, whether they are successful in tackling the due process paranoia is perhaps up for debate, and that's certainly something that we'll talk about during the course of this seminar. Sorry, you were about to say something.
Yes, thank you, Ben. That's a good foundation. Let me just take you up on one or two things. You gave us, you went to town about the impact and effect of due process paranoia. I would like to ask you, what are the different scenarios that may give rise to due process issues or concerns, and how should the arbitrator handle them?
Well, the classic situations are where a party wants to amend the timetable in some way. So a timetable may have been drawn up at the start of an arbitration, but then halfway through the arbitration, a party wants to vary that timetable and vary it considerably. We're not just talking about an extension of time by 1 or 2 days here or there, but extending time by months, or wanting to put in new evidence or change their claim, and even to make entirely new cases. I mean, I've sat as on tribunals where parties have tried to do all sorts of applications, increasingly towards the end of the case, and increasingly when parties have suspected that they may be about to lose, they make various applications to try and change the direction of the case as far as they can see it. And therefore, that then leaves the tribunal in a very difficult position, whether they should dismiss those applications or the requests to change the process in some way, or whether they should agree with them. And they run the risk if they dismiss the application of some sort of due process challenge. On the other hand, if they dismiss the application, then if they allow the application, then they do run the risk of the timetable being blown out of the water and ending up with a much, much longer process, a much more expensive process.
Yes, thank you. Finally, before I go to Tunde, you said something about parties, I mean, the law saying that the parties be given full opportunity to present their case. And then the issue then is, how does this equal treatment, full opportunity, how does it play out in evidentiary hearing? How do you maintain the balance?
Well, that's a very good question, and that is indeed the key question in all of this. As you're well aware, the UNCITRAL took the wording, that same wording from the model law, and put it in the original version of their arbitration rules. But then in their updated version from 2010, it was, if you might say, watered down to a reasonable opportunity of presenting their case as a way, I believe, of avoiding the excesses that people had started to see with the insistence upon getting a full opportunity of presenting their case. I mean, my view is this can only be understood in context. One has to think about what is required in the particular case for a party to present their case, which may not be the opportunity, giving them the opportunity to chase down every rabbit hole and turn over every single piece of paper.
Thank you, Ben.
It might be much more defined.
Thank you, Ben. You may now take your seat.
Thank you.
I call my next witness. My next witness is an interesting person. He has extensive dispute resolution experience in private international law, foreign investment and commercial contract cases. He was a counsel at the ICC Secretariat for over 7 years. Prior to this time at the ICC Secretariat, he practiced in several international law firms, specializing in dispute resolution, asset tracing, maritime law, insurance, structured finance, and debt, capital markets. Tunde regularly consults internationally and teaches alternative dispute resolution and international commercial arbitration at various universities in England and France. He is currently a trustee of ODR Africa. He is also a court member of the Lagos Court of Arbitration and currently chairs the LCA subcommittee on reviewing the LCA rules. He was founding member of the IBA 40 under 40. Mr. Tunde Ogunseyitan, the floor is yours.
Good afternoon, everyone, and it's nice to see old friends and new ones again. Thank you very much. Today I'm going to consider due process in the context of the New York Convention, and in particular, consider whether when we talk about due process, we're talking about local laws or international standards. The first thing to consider is that beyond the norms which transcend international jurisdictions, like natural justice or the French les principes de contradictoire, which are essential principles of natural justice, there is no one set of rules that encompass what due process should be in an international arbitration. But what you do have is, first of all, the laws of the lex arbitri, which govern what we consider due process to be. And when you're doing an arbitration, what you really start considering from the beginning is, as an arbitral tribunal or as a sole arbitrator or a member of three, is whether you are going to flout any rules in any international arbitration. But one thing we must consider when we consider due process as well is not only the law of the seat, but also the rules of international institutions, which might help to mitigate some of the issues that people see or consider as due process issues. The other thing we really need to consider right at the offset is the parameters and the cultural parameters that govern what people understand due process to be, whether you're a Ghanaian arbitrator, a Swiss arbitrator, a German arbitrator. Depending on the seat you're sitting in, it will impact due process considerations. But for this particular session, I'm going to focus in particular on our Article 5.1b of the New York Convention as it impacts due process and enforcement of awards in various jurisdictions. And I'll talk about England, Singapore, and various other jurisdictions. Like Ben, I'll take a international approach before we reduce it down when we get to Mrs. Ademumiro when she talks about specific cases. But I'll talk about hot button topics as well. Article 5 is 1B is where we go. Article 5 provides a basis for refusal of the enforcement of an award if a party against whom the award is invoked was not giving proper notice of the appointment of the arbitrator or the arbitration proceedings, or one was otherwise unable to present his or her case. We see this all the time. For example, when I was working in national institutions, parties, especially governments, don't participate. And then they say on various bases that, one, they weren't giving proper opportunity to select the arbitrator, either if they have missed the opportunity because of time limits under the arbitration rules, or even in the arbitration contract that expired. But the most important thing for 1B, 5.1b, is that the party should be aware that the defense concerns applies only in circumstances where the arbitral procedure is so tainted by procedural unfairness. And that's something quite important for us to sort of piece apart what constitutes procedural unfairness. One thing that we must be clear about is that when we talk about due process, the irregularity contemplated under the New York Convention is that it must be serious and sufficiently serious to be taken into account. We must be aware that the evidentiary burden of Article 5.1b places a heavy burden on the party trying to rely on it. In particular, that defense will not be typically successful if it is beyond doubt that the award could not have been different, notwithstanding the irregularity. So in most jurisdictions, what you have to consider is what is the irregularity or the due process consideration you're thinking that the arbitral tribunal has not complied with. One thing we should take into consideration is we should look at the local courts. And it's important that when the courts considered this ground is not intended for the court to take a different view to that of the arbitral tribunal on procedural issues. What has to be shown is that the party resisting enforcement somehow was deprived of its right to have its substantive case heard or determined by the arbiter, and not focus on whether he gave me more time or not. That's not something we're trying to focus on here. In most developed jurisdictions, the enforcement courts have tended to defer to arbitrators' procedural decisions, and that the application of Article 5 does not typically interfere with the procedural informality or the flexibility of the arbitration. So parties should keep in mind that when they're engaging, what seems normal in the procedural sense in your domestic judicial forum will not apply in international arbitration. But quickly, I will take Article 5.1b's points one by one, which is effectively not being given proper notice for the appointment of our arbitrator of the arbitration proceedings, or was unable to present their case. And I'll take them very quickly. these days, it is quite unusual for parties not to be given notice of the appointment of the arbitrator or the arbitration proceedings. If a party has not actively participated, it's for various reasons, whether strategic or not. What we must be really careful to say is that if they fail to appear, this does not automatically mean that the award can be challenged. What is really important, if you look at, for example, the Swedish Supreme Court decision, is that if you can't show, for example, that you have proper notice of an arbitration, then you won't be that award will be suspect. But really, when we think about it, in truth, most arbitral institutions have dealt with these kind of simple procedural issues. For example, sections 2, 4 of the LCA rules, 3, 4 of the LASIAC rules, and if we consider that in context with the ICC rules, most correspondence will be deemed to have been sent, even if they have been returned, provided the arbitrators can show that they have a proper record. So while arbitrators concern themselves that these kind of simple procedural issues will lead to their arbitration award being struck down, that is not usually the case. But more importantly, let me focus with the time I have left to issues, substantial issues of presenting your case or conduct of an arbitrator in particular. When we look at the United Kingdom decisions in Correa versus Tony Francis, the English court upheld its decision in enforcement of an Indian award that grounds of illness on one of the parties was substantially serious enough to strike down the award, because they said, well, if he's ill, he can't present his case, and if he can't present his case, there's no due process there. And in that context, we can see what the courts are considering to be serious due process issues. The High Court in Hong Kong also reinforced this view, and that is another different procedural aspect, in the sense that the respondent was not given an opportunity to comment on the reports from the expert. So this will sometimes be considered deep procedural issues that can lead to the setting out of the award. But on the other side, serious things like the arbitrator refusing to reschedule a hearing for the convenience of a witness for parties opposing enforcement is unsuccessful. The tribunal refusing to grant an adjournment or denying additional discovery, which in some jurisdictions is quite serious, again was unsuccessful when challenged on the court. The tribunal refusing to grant further adjournments or to stay an arbitration proceedings because of bankruptcy also has been turned down. This is particularly tricky, for example, in jurisdictions like Nigeria. In Nigeria, we've seen that collective proceedings, such as winding up proceedings, are not interpreted in the same way. Those operate as a stay of all order proceedings under the CAMA, Company and Allied Matters Act. However, the Supreme Court has interpreted the provisions of CAMA to say that only proceedings before the Federal High Court are affected by pending collective proceedings, and therefore excludes state and high courts and arbitral tribunals from staying out proceedings. So those kind of applications are unnecessary because the lex arbitri already takes care of them. So when we consider what is quite simply due process, the courts have taken a very, very strict view to the powers and what the arbitral tribunal can do. The bottom line is this: arbitral tribunals don't have to be as fearful as they once considered, because most of the rules that exist in international arbitration, whether in the lex arbitrii or international rules, actually support arbitral tribunal taking bold, firm decisions when it comes to definitely pushing arbitrators through. One thing I want to particularly talk about with the 1 or 2 minutes that I have left is the procedures of institutions. And I want to talk about this in connection with the Glover versus Shell case, which Mrs. Adegbomure will talk about in detail later. But one thing that should be clear, for example, is when parties have agreed to a specific set of rules to govern their arbitration, it is not open for the losing party to use the New York Convention as a de facto appeal of a procedural issue. For that, for example, I'm talking about challenges. If an institution, for example, has decided a challenge and closed the chapter, the New York Convention, Article 5.1b, cannot be used to reopen that procedure. So in the global Shell case, it was clear that the challenge was a procedural issue that was dealt with by the institution, and it is not up for review by the court, let alone constitute one of the lattices that form the basis of a challenge of an arbitral award. So, I mean, it's been roundly criticized by a few distinguished authors. Some people have supported it, but there has to clearly be a fine balance when we're looking at our local courts and how they think what constitutes procedural unfairness, especially if the process has been effectively managed by an institution. And I will leave it there because my time has run out.
Thank you, Tunde. That's a very succinct explanation. Before I go to my next witness, I would like you to clarify quickly. You have before you, we have some polls that we would like you to just quickly click for us. It would inform some of the areas of concentration at this meeting. We have just two polls, which we'd like you to quickly fill it up. We have just about a few seconds more. Whilst we're looking at the poll, I'd like you to look at an issue for us today.
Yeah.
I would like you to tell us a bit, in just a few seconds or a minute, what is procedural judgment rule, the procedural judgment rule, and how it does help in stemming due process paranoia, especially in international arbitration.
The procedural judgment rule effectively, excuse me, sorry. We're talking about a safe harbor in the sense that this gives arbitrators in international proceedings the comfort to ensure that the procedural decisions they're making in exercise of their full discretion is not compromised by what the parties will say. That's the short answer to that question.
Thank you. Our administrator, Dr. Agbelusi, have we finished with the polling? we go on. Now, we have the first poll, if I may just read the result. It says the right to present new evidence, the right to present one's case might have to be balanced against the need for timely decisions. 40% of the voters agree, they strongly agree, and 50% agree. So effectively, you have 90% agreeing, 9% disagree, and 4% is neutral. And then the second question, and this is quite important for our speakers as we go on. Arbitrators should have an inherent authority to protect the integrity of the process, not minding the fear of due process concerns. Ben has made a case in that regard. And 89% of those voting strongly agree, that is 49% agree, and 40% agree. And 1% disagree, and 9% disagree. So what we are saying is that arbitrators we have an inherent power to protect the integrity of this process, not minding the fear of due process. This should give us a lot of comfort and should give us the courage going forward in this process. Having said that, I'll go to my next witness. My next witness is an interesting personality. She's a legal practitioner and partner in the law firm of Shola Jijola and Co. She's a chartered arbitrator and has been a fellow of the Chartered Institute of Arbitrators since 1999. She's listed on the approved faculty list of the Chartered Institute of Arbitrators as a tutor and assessor for the Institute. She has taught within Nigeria and outside Nigeria in other countries like Dubai, Rwanda, and Ghana. Olushola is a tutor at the Center for Law and Business, Lagos, Nigeria, and teaches applicable laws in international arbitration in the external LLM program of the University of London. She's also on the faculty of the College of Negotiation of the University of Lagos, Nigeria, where she teaches international arbitration at postgraduate level. She's a member of the Nigerian Bar Association and a member of the International Bar Association. She's the co-editor with Mrs. Obosa Akpata of the second edition of the Nigerian Arbitration Law in Focus. Permit me to invite Shola Adegbomire, CAB, to take the stand and give your evidence.
Thank you very much, Mr. Oluwanuga. It's a pleasure to be here. I know somebody wondered whether, can you hear me?
Yes.
Okay, thank you. I don't know if I'm representing arbitral women or I'm representing CIR, but I'm happy to be here. I don't also know whether it's because I have had a lot of challenges with due process paranoia. And so I think that I have a lot to say about it because it's a challenge that I have faced myself. I don't know why the camera is very dark, but at least you can hear me. Also maybe because I have taught due process in arbitration and perhaps I have been guilty of fueling due process paranoia myself, as you will see in this paper. Like I said, I've taught it and I've taught an introduction to arbitration class where that has come up a lot. When I found out that there was actually something called due process paranoia, I was quite pleased because I realized that what I go through, many other people go through the same thing, not just in Nigeria, but all over the world, that wanting to be absolutely sure that the award will not be set aside. So thank you, Mr. Oluwanuga, for inviting me to speak on this webinar, which has become our new normal. I'm talking about it from the Nigerian perspective. And so, we can't do that without looking at our Arbitration and Conciliation Act. One thing that I always taught that I still teach is that the basis or the fulcrum of arbitration is sections 14 and 15 of our own Arbitration and Conciliation Act. That same act, since ours is based on the model law, you will find in every other one, but basically it says in section 14, in any arbitral proceedings, the arbitral tribunal shall ensure that the parties are accorded equal treatment and that each party is given full opportunity of presenting his case. And I think that is where the paranoia starts, because as an arbitrator, you are thinking full opportunity, full opportunity, full opportunity. I have to give full opportunity to both parties to be heard. And of course, when you think of full opportunity at times, you are assuming that that means they must have every chance to be heard. There must be no way for one party to say, oh, I have not been heard. And I see this section 14 as the bedrock. Now, when you look at section 14 and you begin to compare with other sections of the Act, there the problem starts. I talk about section 21, and that's another one, we talk about, we set questions on. It's, well, I hope there are no students here, because it's one thing that questions always come from is section 21. And that deals with, whether the tribunal can hear parties ex parte or not. I remember I have always said, look, section 21 says that if one party doesn't come and hear the other party ex parte, don't be in a hurry to hear the other party ex parte. Because if you're in a hurry about what could be set aside, because the other party may then turn around and say, I just missed one date, and they went ahead. Even though section 21 gives one the right to do that. And let's quickly read section 21. So section 21 gives the arbitrator the power. It says, unless otherwise agreed by the parties, if without showing sufficient cause, the claimant fails to state his claim as required, the tribunal shall terminate. Or C, especially, any party fails to appear at a hearing or to produce documentary evidence, the arbitral tribunal may continue the proceedings and make an award. So section 21 gives the arbitrator the power where a party fails to appear at a hearing or to produce evidence, now may continue proceedings and make an award. But I'm also very quick to say to the students, don't think because section 21C says you can go ahead if a party fails to come, then the first time the party fails to come or the second time, just go ahead and finish, So in that way, maybe sometimes have also been guilty, even in teaching. I mean, Ben talked about, what we should start teaching. And so maybe in teaching, we have in a way fueled that paranoia in saying, don't be in such a hurry to hear the case when one party is not there. I've always said. And so we have a situation where a party come once, does not come twice. The arbitrator is worried to go on with the case. But on the other hand, he's worried because he's looking at section 14, which says equal opportunity, full opportunity to present. So he comes in once, then he doesn't come in again, and he comes with all kinds of excuses. You are very worried because you do not want the award to be set aside. And that begins to fuel equal due paranoia, due process paranoia. It was interesting for me to find out there was actually something called that. And it's happening in so many ways. And I find that it's not only in this section 14, section 15, section 21, section 8, which deals with independence and impartiality. We're all very worried when it comes to, I must be careful, I must be careful, I must be careful. And all these things then lead to delays in the hearing. And now some arbitration matters are taking just as long as litigation because one party is taking his time to come to the tribunal, is asking for adjournments, he wants to amend. And we keep saying, okay, we give time, we give time, we give time. I think that we must begin to move away from that. I say that sometimes maybe this paranoia comes when you get deeper into arbitration, when you are more invested in arbitration, you understand, for example, the cost of arbitration. I think the fear of parties having invested so much in an arbitration is not cheap compared to litigation. Litigation, everything is practically paid for by the courts except your legal fees. And the same legal fees, you still have to pay for it in arbitration. I mean, you've paid so much money, and for some reason of due process, the award is set aside. Nobody likes it. The parties are not the arbitrator too. So because arbitrators are being careful to make sure their awards are not set aside, due process paranoia sets in. I say that perhaps when I was younger in arbitration, I was bolder. If you were not ready to go on, I was happy to just, take 1 or 2 dates and move on. But these days, one seems to be a bit more careful, a bit more cautious, perhaps because our courts too are a bit cautious. The courts are cautious, and you know that your award is going to stand or fall at the court. So we say, we're doing arbitration. In Nigeria, at least, the courts have a serious role to play because many people will rush back to the courts after arbitration. So it seems as if arbitration is just a first step to litigation. So you spend so much time in arbitration, and then you then move on to litigation when they're trying to set aside the award. And one thing you want to do is to avoid that award being set aside anyhow. Now, so because the courts are cautious, we also are cautious. When it comes to Nigeria, at least, I know that from year one in the university, you always hear about fair hearing, fair hearing, fair hearing, fair hearing. Fair hearing has been drummed into the lawyers, it has been drummed into the judges. So every little thing, the judges too are being very, very careful. They're being very cautious. They want to make sure all the I's, all the T's are dotted. They want to be sure that nobody has been cheated. And that ultimately becomes the problem, because no matter how much I'm ready to move on, if I know this thing is going to get stuck in the courts, there's a problem. And that's one thing we always have to think about going to court. I mean, I use as an example the case that I was involved in many years ago. That case took 10 years plus to get to the Supreme Court. I think at that time, like I said earlier, I wasn't so worried about due process paranoia. I just thought, do the right thing and just move on. Be satisfied that you have done the right thing, you have given opportunity, and so on and so forth. And then, you can. And so the case of McQueen versus Imokwede, many of you know the case. It went to the Supreme Court. When that case started, and the one party said, they were not participating because I didn't give them the opportunity to do this, to do that. I thought, well, I've given every opportunity I think I should give, and I just went on with it, finished the award. They went to the High Court, and of course, the High Court upheld the award. So I felt, okay, so I probably got it right. But then the case went on to the Court of Appeal, and at the Court of Appeal said, there was misconduct, this, and I thought, so that, for example, after that made me more cautious, that, you shouldn't have done this, you shouldn't have done that. But then the same case went to the Supreme Court, and then the Supreme Court upheld the decision. But today, I would be a bit more cautious in the way I handle these matters, simply because I do not want the awards being set aside. If the awards are set aside, it's not good for the parties, it's not good for the arbitrator. And anyway, so much money has been expended in getting an award that, I always feel it would be unfair if they have to start all over again and things like that. Same thing with global gas. And I say due process is not only about one thing or the other. Due process paranoia comes up in so many ways. It comes up with this issue of impartiality and independence, as it did with global gas, and the court said there was no due process because the arbitrator should have disclosed. And today, it's also something we're always thinking about. How much disclosure do I need to make? Where does it start? Where does it end? We have the IBA guidelines. For me, it's always my fallback. When I'm accepting anything, I check with the IBA guidelines, I disclose. But then there must be a limit to disclosure, to all these things. If not, eventually, arbitration is going to become like litigation. Arbitration is going to become a dispute resolution mechanism where we're there for years. I'm seeing many cases because one party is not ready to go on, they're able to get their award set aside easily. They're able to go to court to go and hang the arbitration. They just hang it there while they are debating on this, debating on that. They hang the arbitration there. And at the end of the day, you're in an arbitration for 1 year, for 2 years, for 3 years. The arbitrators are not either dismissing it, it's just hanging there. And there are many arbitrations hanging there because we're perhaps too scared to just take a bold step. I think that we may have to get to that point where, having done what you need to do, we just continue, which is like what I did at that time, which maybe I'm not doing today. You think about enforcement, you think about setting aside, you look at things like Section 48 of the, let me read that, that as well has to do with due process. And those are all the things we're always thinking about when cases are before us and when parties are asking, especially with the adjournments, with the amendments, and you're thinking you have to grant everything. Because Section 48, for example, says, Section 48A3, the court may set aside an arbitral award if the party making the application furnishes proof that he was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise not able to present his case. That's Section 42. Similarly, under Section 48. Similarly, in Section 52, Section 52, 2A3, very similar. The court where recognition or enforcement of an award is sought, or where application for refusal of recognition or enforcement thereof is brought, may, irrespective of the country in which the award is made, refuse to recognize or enforce an award if the party against whom it is invoked furnishes the court proof that he was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise not able to present his case. I've seen cases where the arbitration has stopped because you are trying very hard even just to serve, just service, and they're being very dodgy, just trying to serve alone causes delays. You go to this address, they are not there. You go to that address, they are not there. Maybe they pop up like a submarine just pops up occasionally. You hear of them, then they disappear. And yet you are worried. We had one case that we served in so many places in Abuja. It took us maybe another couple of months of making sure they were being served. We had proof of service here, proof of service there, just because you are worried that if you don't go through that whole route of making sure they get to know about it, making sure they have every opportunity to come and they don't come, you're worried that all they are doing is they're hiding behind a corner somewhere, waiting for a reason to set aside the award. I think that there are people who, from the beginning, they know that we don't have any case or we're not interested in this thing. So all they are waiting for are grounds to set aside the award. And usually the best grounds are these due process grounds. Most of the grounds in the New York Convention, they are new. I think that, most of the grounds in the New York Convention and even in our local laws are mostly due process grounds. So a recalcitrant party will just sit down and wait for you to slip on a due process banana peel. That's the way I see it. They're due process banana peels. And they're just waiting for you to slip up on one and know that, okay, this is what I'm going to use to set aside the award. From day one, when the arbitration starts, all they are looking at is every step you take concerning due process, because they are notching it up as the grounds they are going to use to set aside the award when the time comes.
Interesting. You have given us so much, and we have a lot to chew on this. Shola, you got me thinking, and you mentioned the global gas case, and
Yes.
in that case, there were two schools of thought that, especially as espoused by a learned seal, Mrs. Funke Adekoya, SAN,
Yes.
when she said, is Lagos really supporting arbitration? Because the judge said, if you are challenged, just resign. And so, with what you are saying, I'm not too sure. With one, you said, yeah, the situation is that, look, you were bolder when you were younger.
I think so.
Now getting old in the profession of arbitration, you're a bit more cautious.
Yes.
In view of global gas case, and if you look at the poll before us today, it says whenever an arbitrator is challenged on the ground of due process concerns, the arbitrator will do well to step down or resign. 31% of the people, I'll end the poll now, says they strongly disagree. 47% is saying that they disagree, meaning that about 76% or thereabout is saying they disagree with the comment. Would you then say, Mrs. Adegbomire,
yes,
that shouldn't we revert back to the days of your youth?
I think so. I absolutely think so, because if we do not, we're going to end up spending years on an arbitration, because, the first person comes up, the matter goes on, then somebody wants to say, I've seen so many reasons for people rushing to court to say, we want this arbitrator removed, we want that arbitrator removed. Each time an arbitrator is removed, you start all over again. If it's removed at a particular point, you have to start all over again, And so at some point, we should say as arbitrators, at least on our part, I've had people challenge my jurisdiction even after the Mekuye case. And I've said, well, I don't see any reason why I should step down. I give my interim award saying I have jurisdiction, but then it goes to court and the court says I don't. And then they have to get another arbitrator. They start the process of appointment all over again. At the end of the day, it's just a waste of time, and everybody suffers.
I will come to that. I'm going to take us on that. My other witnesses when we come to the Q&A period. Before I go on, may I just recognize that in our midst we have some key people. Chief Bayo Joe SAN, who was the trustee of the Chartered Institute of Arbitrators, is in our midst. I welcome you, sir. The chairman of the Chartered Institute of Arbitrators UK Nigeria branch, Tunde Busari SAN, is with us. The past chairman, and my chairman, I always call her before, Mrs. Doyin Rhodes-Vival SAN, she's here with us. And we have a number of secretaries of the CIR. We have Yejide Oshunkeye, we have Obosa Akpata, they are all with us. And also, and most importantly, we have my Lord Justice Peter Afen and my other Lord Judges and Justices who are here with us. It's very important, this marriage, we continue with it so that when we both hear ourselves, we know what to do going forward. Permit me also to recognize my team. I have made a covenant to always recognize them. The team that delivered the CIR conference in 2018, all of them are here with us, and I recognize you and I want to thank you once again. So
they did a great job.
Thank you so much. They have Diane, Isaiah, Bozimo, Rachel, Ozebo, and the likes of them, Michael, SAN, all of them. I recognize you and I celebrate you once again. The chairman of GAIN is here with us. I recognize you. That is Mrs. Upeme. She's in the US. She's joining us from the US. I recognize you. So we're going to go on. We're going to go on with this, and I'm going to be introducing a friend and a mentor who is going to be joining us from Egypt. He's a father arbitrator. He's done it. He's taught it. He's he's dual-hearted, as they always say, dual-hearted. He's the chair of private international law and professor of international arbitration, Cairo University, the vice president, ICC International Court of Arbitration, member of the ICA governing board, vice chair, ISDS Academic Forum, member of the MEAC Advisory Board, vice chair, IBA Arab Regional Forum, CIMAC court member, member of the CRC-ICA Advisory Committee, member of the CIR Board of Trustees, Dean of Africa Arbitration Academy. Professor Dr. Abdel Wahab served as arbitrator, counsel, and legal expert in more than 200 cases involving African, Asian, Canadian, European, and Middle Eastern, and US parties. He features in IAB Africa, 100 leading African practitioners, and was selected the African personality by Africa Arbitration in June 2018 and by LASIAC in May 2019. He received the 2018 ACA International Arbitration Advocacy Prize, the 2019 AYA Hall of Fame Africa Arbitration Award, and the 2020 Client's Choice International Award. The Legal 500 2019 states he is one of the best in the world. I confirm that. WWL Arbitration 2019 says he's a leader in the space and a very well prepared, exceptional arbitrator. WWL Construction 2019 says he is a leading heavyweight construction law specialist whose analytical skills are second to none. Permit me to present Professor Dr. Mohammed S. Abdel Wahab, who is my key witness and is my expert witness to deliver Paranoia in arbitration at this conference. Thank you very much, learned Prof.
Thank you very much, Mr. Shola. It's a pleasure to be amongst those leading figures and leading lights of this panel and our preeminent participants. This is a very topical issue, and let me just cut the chase and say the following. Again, I am delighted because this topic to me is an interdisciplinary one. It cuts across law, culture, and professional approach to prosecution of arbitration proceedings. It is an area where many legal concepts, cultures collide. Let me start by saying when we talk about due process, paranoia, there are three words that merit due consideration and reflection before we move forward with practical applications, as I intend to. Paranoia, when we look into the books of mental health psychology, we will find that it's a mental condition characterized by delusions of persecution. So the key word is delusion. It is an aspect of chronic personality disorder mounted on a belief of exaggerated perceptions of conspiracy. Isn't that the case when counsel flags due process concerns? And I must say, the caveat, we need not have an inappropriate predisposition that any due process objection is frivolous. This is not true. There are valid due process considerations, and I will come to that. But it is quite telling of this definition, how it has been imposed and transplanted into the world of international arbitration. In Greek, this word means madness. starting paranoia means madness, and is a symptom of what we call psychosis. It is an abnormal condition of the mind that results in difficulties in determining and distinguishing what is real from what is an illusion. All this pulls into the contentious type of discussion we're having in the context of arbitration. To me, in arbitration, paranoia would constitute a chronic professional disorder leading to irrationality due to delusions of persecution. With that in mind, let me move to due process itself. And due process in law is a phrase that has been imported and originated in American jurisprudence in the 5th and the 14th Amendments to the US Constitution, and embodies the society's fundamental notions of fairness, hence its connection to public policy. Another big monster and elephant in the room that is misleading to many. To use Lord Denning's word, you need a person who curbs this unruly horse in a way, talking about public policy. But due process in any way, as we've seen it, refers to fairness. And fairness to many is a function of subjective assessment. It has haunted and daunted humans ever since the dawn of time. You will find cultures, communities, professionals disagree on what constitutes fair and unfair. This is all compounded when one has a stake in the arbitration himself, be it as counsel or arbitrator. The views differ. But one thing is in common, is that it is a very hot topic that merits more and careful consideration. So due process involving substantive or procedural elements is grouped into 4 groups. Being given due notice of a case or proceedings, and I guess this is much less contentious because normally people are notified. The dispute always arises in relation to whether you have been notified through formal means, de facto notice or otherwise. Then we have the 3 other aspects, is being given a proper opportunity to present one's case. And I'm using the word proper cautiously because we will find national laws differing on the use of full or reasonable opportunity to present one's case. And when an arbitrator sits in a case, they have to be mindful of the myriad of laws at play and not measuring this based on their own culture or background, but taking into consideration the applicable laws being procedural or substantive, looking at the seat and at the place of enforcement ultimately, and how courts construe reasonable or full opportunity. And thirdly, being entitled to appear before an impartial and neutral or independent arbitrator. And here it's a very big point that I have a proposition that I will end with to reduce the, let me say, problems that we have or challenges in relation to due process. But indeed, very important. And in fact, appearing before an impartial and independent tribunal was at the heart of the GGRL versus SPDC case in Nigeria, with my esteemed colleague Professor Sola has kindly touched upon. And then finally, being entitled to an equal treatment. And here is one of the areas where we see a lot of objections, because many people would measure equality quantitatively, ignoring the qualitative equality that this term may bear. So you will have polarized views about equality, should it be mathematical, quantitative, or qualitative and non-mathematical in a way. We also have a seminal lecture delivered by Professor Lucy Reed in 2016, the Queen Mary School of International Arbitration Freshfield Lecture on the abuse of due process, a sword or a shield. And she gave an overview of what due process entails. And just to mention and give the credit due to her, she mentioned that due process is a shield of fundamental procedural rights before deprivation of substantive rights. She defined and contrasted due process to what we call ordinary process, which are decisions acts and missions taken by the arbitrators in the ordinary conduct of the proceedings to safeguard the integrity and efficiency of the proceedings at large. And here I recommend to many of you the ILA 2016 resolution on arbitrators' implied, inherent and discretionary powers. Arbitrators, to perform their function without being fearful of prosecution or challenge, need the comfort of a degree of power that should be implied and discretionary in their decision-making process. That said, the caveat, and I think the pitfall many fall into, arbitrators are not gods. They should not act like gods without giving the parties the due consideration and the benefit of the reasoning that they deserve regarding decisions they make. Now, with this in mind, I will move on to address with you the common types of alleged breaches of due process and touching upon practical applications that I have personally either witnessed or seen before courts in no less than 10 or so countries, including the UK, Malaysia, Singapore, Nigeria, the UAE, Lebanon, Egypt, France, Switzerland, amongst others. The common types, you would have issues of due process regarding institutional decision-making, when it's institutional arbitration, on case registration, processing of applications, determination of challenges, inadmissibility of counterclaims if fees are not paid, and the like. And the same, of course, applies in ad hoc arbitration, but the tribunal would be, to a large extent, either the victim or the party to these challenges. And then equal time allocation, the chess clock syndrome or requirement. The party is playing the game with a chess clock, should understand the parameters, and the tribunal should clarify what is expected in terms of equality. Is it simply equality of time or equality of treatment? And I don't think that both are one and the same. Who speaks last on what? This is again a function of a dichotomy between civil and common law. In many common law jurisdictions in litigation, claimant may speak last. In civil law, this would be shocking. In civil law, it was the respondent that speaks last. In arbitration, we have bridged the gap, and international arbitration, I think it's a recognized default rule, unless displaced by the parties. The respondent would speak last on the claim, and claimant would speak last on the counterclaim. Time extensions and unsolicited communications, how these are being handled, and they can give rise to due process objections. Requests for exclusion of evidence or last-minute inclusion of evidence, and also limiting the rounds of written memorials, the context of these memorials, word limit, and what they cover. Limiting oral pleadings or examination of witnesses, be them factual or expert witnesses. Dispensing with a hearing on the merits, and now the compounded effect of COVID-19, dispensing with a physical hearing and opting for a virtual hearing potentially. And finally, an area that has not been given much thought, though I have seen in the chat, especially by my esteemed colleague Tundi, has made reference to it, Jura Novit Curia. To what extent arbitrators can address arguments or raise legal authorities that have not been invoked by the parties, to say a few. It gets even much more complicated. One example I had in a case was one party applying for the joinder or extension of arbitration agreement on the basis of 2 or 3 theories or legal principles. The tribunal is at odds because maybe none of the 3 is applicable, but a 4th principle can grant the extension or joinder. Should the tribunal take the lead on the basis that the claim is being made, even though the theory itself and the principle has not been flagged, and join the third party on the basis of a principle that has not been invoked, let alone defended by the other party who has not had a chance to see this? Definitely questions of due process cut across all this. Late introduction or amendment of claims, defenses and counterclaims, considering certain types of interim relief and provisional measures and the treatment of the tribunal of these applications. And finally, the newcomer in our field, which is technology as a trigger of due process concerns or objections to a large extent. Now, before briefly touching upon the applications that I've seen in real life cases, I will say the following. I've been following the poll, and I'm very grateful for Mrs. Sola Ephraim for the excellent poll questions, one of which is the question of whether a challenge over due process concerns requires the arbitrator to step down. And as indeed we've seen from the poll, 47 or 48% said no, the arbitrator should not step down. But I'm more interested into the 18% of people who either strongly or simply agree that they should step down. And I think the 18% of people who voted strongly agree or agree that the arbitrator should step down, it really lies into the use of the word concerns. And I would be interested to see if we were to replace the word concern with allegations, this may lower the 18%. I'm simply saying that because concerns can go either way. There could be valid concerns, there could be invalid concerns. But allegations would very unlikely result in an arbitrator stepping down, or for rational people to agree that on the basis of a sheer allegation, a person should step down. Now, moving with the allegations, with the practical applications, that in one case involving parties from Italy and Kuwait in a London-seated arbitration, in which we prosecuted as counsel, my firm, the opposing party moved to introduce a counterclaim 2 weeks before the hearing with a $1 billion new head of claim. We fought the application, and the tribunal, composed of civil and common law practitioners, so it's a mixed tribunal or a hybrid tribunal, struck the application of the introduction of the counterclaim off. And the counterclaim was not admitted because it was too late. It was not based on new facts. It was simply a tactical move. The tribunal was not persuaded by the quantum, which may have affected the fees of the arbitrators, and took the right decision to strike it off. But disregard my view on the point because I was counsel. It was the English court that took the view based on an application of breach of due process by that party filed before the English court in a confidential proceeding. The English court said the tribunal was right in striking this off. There is no breach of due process. The requirements of efficiency, as opposed to a disruption in that case, because the admission of that belated claim, irrespective of its merit, would have resulted likely into the vacation of the hearing date, starting the prosecution of the proceedings again relating to this counterclaim. And the English courts, having stricken this off and said the tribunal was right, went a step further and said the party that brought this application before the English court will not be permitted to challenge the forthcoming award on the basis of denial of this application in setting aside proceedings. So they preempted this by taking this a step forward. One case. Another case is the Malaysian High Court case in the Allianz General Insurance versus Virginia Surety Company case, 2018, where the Malaysian High Court dismissed a challenge to the award on the basis of due process breach, on the basis that the party that challenged the award said that we have brought a manifest breach of good faith argument that the tribunal only addressed in 3 to 4 paragraphs in their award. And so it was not been given due consideration, due attention. The reasoning so reflects, and so we are entitled to challenge the award. The Malaysian High Court again rendered this objection inadmissible and said that the tribunal, to the extent that the majority award in its entirety addressed the claims and counterclaims of the parties and defenses, they are not bound as a tribunal to address every single claim or argument to a measure the party so desires. And natural justice has not been breached accordingly, and it is for the tribunal to balance the considerations of reasoning to the extent that the reasoning stands valid and sufficient overall. So again, a clear response from the Malaysian courts. The Singapore courts, and this also I had in mind, had mentioned in April 2018, and I recognize our colleague Festus Onia has mentioned that in the chat box. The Singapore court again refused or declined to set aside an award because the entity, which is the Chinese entity, wanted to set it aside on grounds of breach of rules of natural justice, breach of the arbitration agreement on the basis of equal treatment, and lack of an opportunity to present one case, and the breach of the rules of public policy in Singapore, and the arbitral tribunal's failure to investigate allegations of corruption. The Singaporean court addressed all these in 3 separate heads under the due process ground, defective arbitration procedure ground, and public policy and corruption ground, and dismissed them all in a well-reasoned award. In a third case that I was involved personally on the arbitral tribunal, one party moved again to bring a counterclaim before the hearing on the basis of a development that that party alleged. We as a tribunal told the party, you can do so and you have a week since you want to bring that counterclaim, and the other party would respond and we will proceed with the hearing. The party said, no, a week is not enough. We need about 3 to 4 months, even though that they acknowledged that the facts of their counterclaim is ready, but when they were given a week, they declined to proceed. They threatened court proceedings against the tribunal, and we told them you are absolutely entitled to do so, and you can do so. The seat was London. The party did not go to English courts. The award was rendered. The reasoning was there. We made the careful choice not to express views on the counterclaim that was not procedurally admissible, so that that party has its opportunity and day in court if and when it desires to prosecute a separate case in this respect. Another case in relation to the Jura Novit Korea, where the party brought a claim. The basis of the claim was on the basis of commercial law, even though the case was to be prosecuted under the Vienna Sale of Goods Convention. The tribunal was then in the awkward situation, should we flag this to the party or not? Would that be an assistance to that party or not? But ultimately, the tribunal had to render its award. And to avoid surprising the party with an award, the tribunal made a generic reference as to whether both parties consider any other instrument or a convention applicable to the proceedings. Counsel was not aware of the Vienna Sale of Goods Convention. Both parties researched the matter and provided submissions for the tribunal to render its award. When the court was seized, even though they were given opportunity in setting aside proceedings, the court endorsed the tribunal's approach and said this was not an assistance to one party over the other. Both parties were not surprised, were given the due opportunity to present their case, and so there is no breach of due process, and the tribunal has done well. These are just but few applications. I guess with the COVID-19, the use of technology, be it reliable or unreliable, the leaving of the comfort zone of counsel in prosecuting cases and cross-examining witnesses, the objections to time extensions or new applications will continue to be all-time favorites, and will continue to grapple with due process at large. But in principle, I leave you with 4 messages for tribunals. Tribunals need to be careful, but not fearful. Tribunals must be prudent, but decisive. They should be wise in their reasoning, but should not surprise the parties. They should avoid a stigma and a predisposition about respondents or claimants in proceedings. They should prosecute the case on the basis of claims, arguments, and evidence on record, irrespective of the trading places of who acts as claimant or respondent. Avoid acting like gods in terms of being stringent with reasoning or denying the parties the opportunity of a proper reasoning of the award on the basis that the number of pages would be too many to sign. The parties deserve good reasoning without an overly unnecessary reasoning. And with that, I recommend to you the very recent report by the ICC in relation to the reasoning of awards. Is it to the losing party or to the winning parties? I guess our discussion over due process does not end today, but certainly offers a lot of opportunity and thoughts to reflect on for the years to come. Thank you. You are on mute, Sola, so we can't hear you.
I said I did not expect any less. Thank you so much for the thesis and for the way you broke it down. And I would not waste time to say that I recognize that 4 cardinal program and 4 cardinal points. Be careful, but not fearful. I think based on that, we can leverage on that and go into the world and preach the gospel of arbitration. I will not take time to begin to cross-examine you. I would allow, before then, permit me to recognize 2 of my mentors and friends and mentors, Professor Wakwe of the Abuja University, and then Professor S.A.N., my brother, friend, and mentor. We spoke this morning, so permit me to recognize them. Now we're going to go into questions. There are lots of issues that have been brought up, and some of them you've looked at. Can we have, before then, we're going to have Tunde. Tunde would like to say something.
No, I just want to take Professor Wahab on what he said about replacing the word concerns for allegations. And this particularly relates to us, and especially in Nigeria, where an allegation is an allegation until it's proven otherwise. And what Shell versus Global says, as soon as there is an allegation, then you should step off. So even swapping the word allegation for concern doesn't deal with the problem, in the sense that what we should really look at is the process of which that allegation has been dealt with, and if there's a proper process, and that's distinguishing between institutional arbitration and ad hoc arbitration. Where do you go if you have a concern? If with most institutions you have a process that deals with your concern, i.e. if you have a problem with an arbitrator, you want to object to that arbitrator. And Professor Wahab has sat with me several times at the court when somebody has objected as to whether an arbitrator should be confirmed. And then we look through that allegation. If the institution has done that process, then that should be the end of that. It shouldn't be.
Please go ahead whilst you're waiting for him to do the poll. The polling, let's go on with the polling while you're waiting for him.
It shouldn't be open to a review again once the arbitrator is confirmed. They can be challenged. Again, another process which is subject to review. Now, once that procedure is completed, is it open to the courts again, at least to revisit that procedure, given that, I mean, the context I viewed it, even in the UK Arbitration Act, they wouldn't look at that procedure in order to decide whether to enforce an award or not. So changing allegations to concern might change the word, but it doesn't fix the problem, because anybody can make an allegation. The substantial part of it, according to that poll, is that we can't look at simple allegations as the basis of recusing ourselves. It's literally going to battle with one hand tied behind our backs, especially in problematic jurisdictions where they will fling as much mud as possible and as you said, some people who apply guerrilla tactics.
Thank you very much, Prof. Would you like to talk about that?
Yes, thank you very much. Tunde, I'm absolutely delighted to hear what you say. And let me be candid, since I'm an outsider about this. I think Nigerian courts, on the principle of as soon as due process allegations or concerns are flagged, the arbitrators should step down. I think they need to reconsider their position absolutely if they were to be positioned as an arbitration-friendly jurisdiction. And I guess this is not news. I also read my dear colleague and friend Funke Adekoya's analysis of this, with which I concur. And let me say the following. This has been addressed, for example, by Egyptian courts and others in a very similar situation where a party who did not want the presiding arbitrator on the case for no reason went and filed a case against that arbitrator and brought it as evidence that now he is an opposing party to court proceedings, and so there is no independence and neutrality. And the position was that this is an engineered post-fact case filed, and so it cannot form the basis of valid due process or removal concerns. And the point is, if we allow a party to bring simply an allegation and the arbitrator to immediately resign, irrespective of the process or the validity or even sensibility of that objection, we are creating an opportunity for counsel to strategically, and let me use the word, it was last year's event, the guerrilla tactics, it will be a valid guerrilla tactic under the umbrella of the court, endorsed by them in a legitimate process, which I think would be amiss and completely at odds with how justice systems operate.
Thank you very much, Prof. Some people have spoken today and they've said due process and natural justice are intertwined. Ben, would you like to just say something about that? Due process and natural justice? Someone asked, are they intertwined?
Well, yes, they are. I mean, due process is an essential part of natural justice. And I mean, one might say that they're two sides of the same coin. But due process always has a context to it. Due process must be assessed in light of everything else that is going on, and in light of everything, all the aspects of the case. Whereas natural justice, I would say, is rather more essential than that, and less dependent on all the circumstances. Could I just also mention a point about that Sola raised earlier about, if I might say, wisdom coming with age? Certainly, the finest arbitrators that I've seen who have dealt with due process issues in the best way are those that have acquired considerable experience and have been able to identify, well, two things. Firstly, they've been able to identify the various approaches that some parties take towards due process and anticipate these approaches in advance, but also then deal with them in a very human and humane way. Because very often that is the appropriate way to do it. I sat with a very distinguished arbitrator in Singapore who has a very disarming approach to parties that involves considerable amounts of humor. So he will say, do you really want to spend so much money on this party or case? Do you really want to take so much time? And he does it in such a delightful manner that very often disarms and removes the tension out of some of these due process issues. There is a lot of tension in them, and to be able to anticipate them and disarm them I think is a tremendous skill and one that really does come with experience.
Thank you very much. Prof, I would like you to share more experience about the case you mentioned on discovery, when a party springs up new evidence just before the hearing, and what the tribunal situation.
Thank you very much. Well, I think this can be broken down into a number of issues. Evidence before the hearing sometimes is not uncommon at large. It is normally up to counsel to discuss this amongst themselves and come up with a joint proposal to the tribunal that the tribunal can consider. When the tribunal, if the parties are in disagreement, the tribunal needs to consider a number of factors. First of all, is this new evidence in light of new facts that have recently arisen, or was it simply evidence that one party had all the time and decided to file last minute? Is it factual or legal? I'm saying this because in some legal systems, depending on where you're sitting, what the procedural law is, and sometimes it's a question of entanglement between substance and procedure, unless the proceedings are closed, legal authorities in some jurisdictions could be filed. So the parties need to address this heads-on in their procedural orders. The tribunal needs to make it clear to ensure that the parties are well aware of how the proceedings are going to be conducted. But if one party surprises the other with evidence at the 11th hour that is unjustifiably filed at that time, not based on new facts, I think that would be a problem for that party. And it will not sit well with the tribunal. And even if the tribunal admits this for whatever reason, for avoiding last-minute debate or dispute over this and giving the other party the right to respond, even on that occasion, the tribunal may take that into consideration based on an application of the other party. But that is one aspect of it, because again, there could be valid reasons why this was filed at that time. So it's a test of assessment. And again, the tribunal needs to consider and take an informed view before deciding the matter.
Thank you very much. Mr. Debomiri, obviously the ACA, which you talked about, does not exactly define misconduct. And a few people are asking the question that, how will you advise practitioners who want to be as courageous as you were at the beginning to guard against misconduct?
I mean, one just has to be, maybe like Prof said, be careful but not fearful. I mean, you have to look at, I always say, look at the end of anything. When you're starting, look at the end. I always look out for any ground that the parties can use to set aside from the beginning. Because like I said, there are parties who are looking at the end from the moment from commencement, they're already looking at enforcement. So I think if as the arbitrator, you always have an eye on enforcement, it would help you to be careful, not fearful. And also we have to understand that in Nigeria, for example, as in many jurisdictions, I guess, it's the courts. All what we're saying actually ends at the court. And so if the courts themselves are careful and not fearful, then we would not have so much of a problem with due process paranoia. If we're sure that the courts are just going to be as bold as I was then, and maybe as they were then we're all sure that, we can go on and there'll be no problem. But these days, I mean, you have to be really careful, just not bordering on fearful, but you have to be really careful because like I said, you don't want to do all that work. And then it's not set aside on major ground. It's just set aside on something that to you might look so flimsy because you didn't give enough adjournments, you didn't give enough opportunities to amend. Not that you didn't give them the chance, but you just didn't give what is considered enough. And of course, when it comes to impartiality and independence as well, you did not disclose enough. there's no end. So I think ultimately, I wish there were more judges as well, on the panel, maybe one judge on the panel, or I'm sure we have some judges listening, and we have our part to play, but the judges have their part to play, because when the award is done and dusted, it leaves us and it goes to the courts. And that's where the action on due process really begins.
Thank you very much. Mr. Godwin, let me say a few words now, or Chief Ojo, is online. I'll take a few words from them.
Yeah, thank you, everyone. This has been a fantastic conference, very enlightening and enriching. I just want to add that, due process is a real issue. And for every arbitrator, we have to be concerned about that. I recall I was involved in an arbitration a few years ago where one of the parties just decided not to show up. And just like Mrs. Adebomire said, we had to take every step and do everything we could do to ensure that we served the party with all the processes. The proceedings went on, and at the end of the day, we got our award. After the award, he brought a certified challenge at the Lagos High Court, and it was refused. So I think the most important thing is for the tribunal to be careful, for the tribunal to be fair, to be even-handed, so that at the end of the day, if there is a challenge to that proceedings, then of course, every fair-minded, objective person will have said that the arbitrators had carried out their responsibility properly. And that brings me to the global gas case. I understand the overall sentiment about the case and how bad a decision it is. But I just want to point out that I don't think I share the comments by Mrs. Adekoya, the screamer, when she said, Lagos, to the extent of the decision, Lagos is anti-arbitration. I don't think that is the case. The courts in Lagos have been very supportive of arbitration. Most of the decisions from the Lagos High Court have been very supportive of arbitration. I think Lagos will continue to remain an arbitration-friendly venue, just to, dovetail into the point that was raised by Professor and Dr. Mohammed Abdul Wahab. So thank you very much, gentlemen. I don't want to take too much of your time.
Okay, thank you very much. Chibayo Joe's network is not working well, but he said his take is that the decision of the Lagos High Court misapplied Section 8 of the ACA and will rather align with the English Court of Appeal in Ali Burton versus Chubb. Mr. Ogushoito, please could you just give one or two words? You mentioned that many times the government parties, especially state parties, don't take part early enough in the arbitrations and eventually now come to challenge the decision of the tribunal or try to come in late. What do you think accounts for this, and how can we, as practitioners, work in this?
I think there are a couple of things there. If you, as a party, do not turn up, then that's your obligation. If you don't know about an arbitration, that's a different thing. But if you use it as a tactic to delay the arbitral proceedings, then it's a waste of your time ultimately, because if you claim, like some councils from various jurisdictions I've seen, claim not to see the documents when we have the email read receipts because you feel that your jurisdiction is somewhere that has dodgy internet connection. Again, that filters back into what Professor Abdul Wahab was saying, in that in the current circumstances, the excuses that are used by people to not engage properly in proceedings is one thing, and I think any court will be able to differentiate that from something more substantial, like if you've not been properly heard, or if you've misapplied the procedure per se, by not giving the parties an opportunity to be heard. There's a lot of talk about fear of the arbitrators on the other side, but I think arbitrators should not be fearful to take the right steps, provided they're experienced enough to handle the disputes in front of them. One thing I see quite a bit is that younger arbitrators tend to make more of these kinds of mistakes by being pressured by the parties. During this COVID era, for example, while I was still at the ICC, we couldn't get the awards notified through the normal means, i.e. a hard copy. So the parties had indicated that they would accept an electronic copy. Then one of the parties changed their minds, and both parties then pressured the sole arbitrator to release the award by email. Then one party objected subsequently, saying the procedure was out of whack. Now you can understand why they did that. If it was a more experienced arbitrator, he or she will have stopped the procedure dead and said, we're going through the normal rules. But because that arbitrator was inexperienced, they were pressured to breach the procedure ever so slightly. It wouldn't ultimately matter, because as I said in my presentation, the issue is this: that breach in procedure, will it change anything substantially that the court would like to review, i.e. that decision, will it change the substance of the decision? If it doesn't, then it shouldn't impact the award. I just saw Chibajo's indication that it would put us in a similar position to Halliburton versus Chubb. The problem with making that comparison is we're still waiting for what the Supreme Courts will say ultimately in the new judgment that we're waiting for. I think we should already have had it, if not for COVID. In that particular case, for example, it was based on Sulibashi, and the issue is this: it's a simple disclosure issue. What are your obligations to disclose? And if you've disclosed once, is it continuous? That is a due process consideration, disclosure, which is quite fundamental. But even the courts are reviewing how serious it is once you've given the parties an indication that at least there is something to see here. You have to do more.
Thank you. Thank you, Tunde. I thank you very much. I'm sorry the technology played its part, and we have to round up here. We have a number of questions that we have not yet handled. I have discussed with the speakers, and they have promised me that some of these questions we can do a video of them, send them to the participants who have asked the questions, or send it in a written form. So we should just have your closing remark in just a few seconds before we do the other aspect of the program. Ben, do you have any closing remark? And thank you, Dr. Agbelusi, for standing in for me. Ben, do you have any closing remark? Just 5 seconds.
Well, just to say thank you to you for inviting me. Thank you to everyone for listening. And this problem won't go away. I mean, it's essential to arbitration, really. But the only thing I would stress is it is something that should be addressed at the outset, and anticipating these issues is key to addressing them.
Thank you very much. Shola, any other closing remark? Please permit me to say that Chief Odien Ajumogobia does not support what Adekoya said. According to her, even the judgment of Global Gas case has not said and does not remotely mean that Lagos is closed or Lagos is anti-arbitration, because all it was construing that the court was saying that any circumstance likely to give rise to any justifiable doubt, that is the key word. So with this, I would like you to make your closing remark, Shola. Few seconds.
Okay, thank you. And okay, so I'll consider going back to my younger self. Hopefully the courts are going back to that age. So arbitration will be what it truly is meant to be. So speedy and straight to the point. That's what we all look forward to, so that we don't have arbitration. We finish the arbitration and then we spend another 10 years litigating the arbitration.
Thank you very much. Prof, sorry we can't take you. Professor Adonige, I'm so sorry they had to blank you out, but thank you very much. The chairman, please, I would like you to give the final comments. You couldn't speak when we began. Give the final comments and thank our speakers. Chairman, Mr. Kifasi.
My name is Danladi Kifasi, Chairman, Planning Committee.
Yes.
I apologize for the technology problem. I didn't connect initially. It is my pleasure to, on behalf of the chief hosts and members of the Planning Committee, to thank our eloquent speakers for the concise and informative presentations they've made today. We want to thank you especially for gracing us with your time and allowing us to drink from your wealth of knowledge. As a sign of our sincere appreciation, we'll be giving each speaker a plaque. I want to specially recognize Mrs. Shola Adegbomire, Chartered Accountant, Ben Gerrit, Chartered Accountant, Professor Dr. Mohammed S.A. Wahab, Tunde Ogoshetan, Fellow Chartered Accountant, Chartered Arbitrator. Also, we want to thank every participant for taking out time out of your busy schedule to attend this webinar. I trust that we have delivered up to your expectation and that we have all been enlightened. For me, it has been a very rewarding experience. I have a few announcements to make. The recording of the event will be sent to everyone. 2, all unanswered questions will be collected, answered by the speakers, and sent to you. Once again, thank you all for participating in this great event. We look forward to seeing you once again next year. Thank you.
Thank you very much. Thank you so much. We are so grateful. We're so grateful sorry, we took 2 minutes out of your time. Thank you so much. God bless you. Professor Donige, I'm sorry once again. Now you are on. You're on. Please, can I just take, please, if you don't mind, Prof, because of what Prof did this morning and called me, Prof, can you please just say something in closing?
Okay, Shola, thank you very much. Let me thank you once again for packaging this event. Last year, you challenged us and we talked about guerrilla tactics. This year, it's due process. You are very imaginative, very innovative. I like that. I like that. So I want to commend you and urge you to continue pursuing your career this way. I'd prepared for the webinar, but I don't have time now. Like Shola Adegbomire said, this is an ongoing discussion. Like the Hondas will say, discussion continues. Thank you very much. Bye-bye.
Thank you. Thank you. And sorry, Chief Bayo Ojo is now available. Do you want to say something, sir, before we close, sir? And then close the meeting for us, sir. Chief Bayo Ojo. Chief Bayojo, is he on? Okay. Since Chief is not on, I want to thank my lords, Justice Raleigh, Hammond. I want to thank you, my Lord, Lord Justices, Lana Silk. I want to thank the chartered arbitrators, particularly the chartered arbitrators turned chartered accountant. Another Philip has been added to your hearts today.
Exactly.
So, yes, I want to thank you. I want to thank everyone. I want to thank my team. God's glory. And Anna, Ikechukwu, Oji, Emmanuel Oji, Olufemi Obamonire. I want to thank you all. I want to thank everyone who has done one thing or the other concerning this meeting. I want to thank Chisholm, who is going to be compiling the report. I want to thank you all for everything. I feel like not going, but really we have to go. We'll see you. We may not be next year, maybe before then. We will see you. Thank you very much. I will confer with my mentors, and what they advise, we will do. Thank you once again. God bless you. And thank Reverend Agbelusi, who has the back end. Thank you so much for handling this and for stepping in. Thank you. Thank my friends from India, from the different parts of the world, and my other professionals who are not lawyers. I thank you all. Thank you so much. And bless you.